Wednesday. Welcome to Wednesday of Sunshine Week 2022. My name is Todd Fettig, and I'm the Executive Director of the National Freedom of Information Coalition. The NFOIC and Uncovered are delighted to present Lighting the Way, Illuminating Information and Innovation, which is our webinar series that concludes with today's discussion that is both inspiring and practical. You will leave here today with examples of how FOI can unlock data and information, and with skills to put your knowledge to work in solving problems. We are delighted to present Sparking Discovery, using FOI and Big Data to tell stories, build community, and solve problems. I'm going to turn it over to Ashlee Fujawa, who is the co-founder and head of community for Uncovered, which I saw on Twitter today just announced that it filed open records request in all 50 states. So that's a good milestone. So take it away, Ashlee.
Yeah, thanks, Todd. Way to scoop me, but here we are. No, thank you so much for hosting this and allowing us to be part. As Todd mentioned, my name is Ashlee Fujawa. I'm head of community with Uncovered, where we're building a comprehensive database of all the unsolved cases of the murdered and missing. So our intention is to utilize that information to help spark people who are interested in true crime and move them from just consumption, but to advocacy. So we're pulling in all the publicly available data. So anything from a news report to a documentary, even podcasts, but any public records we can also access, and visualizing those in a way where they haven't been before, with a timeline, photos, all sources, and an opportunity for people to contribute to crowdsource more information. Our intention is to be able to help solve the more than 250,000 unsolved cases that currently exist in the US with the help of the community and collective impact. So it's so wonderful to have partners like NFOIC, not only to have access to experts, but to really show the thoughtful way to be able to access information. So we are incredibly grateful for this partnership. And as Todd mentioned, today we're marking Sunshine Week by announcing that we have filed open records requests in all 50 states to access that information, which unfortunately does not live in one comprehensive, accessible database for people. So as we're pulling in that information, we're making it publicly available as well, and making it easier for people to consume. So we're delighted to be able to host today, co-host with NFOIC, and to be able to offer an opportunity to learn from two amazing experts in this field, Grace and David, to specifically talk about the basics for accessing and filing for access to public records, but then what happens when you run into roadblocks or if you have to maybe approach from a litigation standpoint. So without further ado, I would love to turn it over to the both of them to introduce themselves and their background, and then we can kick it off with David. So David, do you want to introduce yourself?
Oh, thanks, Ashlee, and thanks everyone for showing up on this sunny week. I'm David Cuillier. I'm an associate professor at the University of Arizona School of Journalism and board president of NFOIC, and former journalist, and now just addicted to this stuff. So thank you. The fact everybody's here means you care about this. Grace?
Hi, everybody. My name is Grace Cheng. I'm currently the director of the government service at Practical Law, Thomson Reuters. I'm a former federal government attorney. I was the head FOIA attorney for the U.S. Department of Homeland Security for about a decade before going to Thomson Reuters. And I'm incredibly excited to see all of you here. FOIA public records is vital to the functioning of our society and of our democracy. So I'm excited that you're all here to learn more about it.
Wonderful. Thank you so much. So those pedigrees, amazing, right? So let's all sit down and get ready to learn from the experts. So David's going to kick us off by walking through the basics. So get out your notepads, get ready to ask any questions. Feel free to offer those into the chat. And we'll also have time at the end if you have any special questions as well. So it's all yours.
All right, let's get rolling. I'm going to share my screen, and in the chat, I've put in some handouts. So I reference a lot of resources. They're all in the handouts. You can take a look. You'll see all sorts of links and other things in there. I also put the PowerPoint as a PDF in the chat in case, so, you know, I go pretty quickly through it, so you don't have to be rushing and taking notes. You could download it if you wish. out of there. And I'll also watch the chat as well. So as I go along, if you have questions or comments, feel free to throw them in there. I'll try to keep an eye on it and maybe at times stop and address a question, or maybe we'll wait toward the end as well. We'll play it by ear. So, so here we go. I'm going to share my PowerPoint and get this going. Okay, so let me move the chat here where I can see in the middle. You know, we're getting all good at this Zoom stuff, right? It's only been 2 years. Okay, here we go. So there's the handouts. Also, there is a book on this whole thing, The Art of Access, cheap plug. But you know what, little tip, the handouts, it's like 70 pages, has most of what's in the book and then some. So you don't have to buy the book. The handouts are free. And feel free to disseminate. And what I'm going to cover today is basically 6 steps to getting records. 6 ways of getting in a document state of mind and getting the information you need. So step 1, let's start with that. Getting in a document state of mind. Now, this is the critical thing. A lot of times we don't think of this, no matter what our purpose is. And what we're talking about is, you know, acquiring government records, anything that's recorded by government, held within government, in the control of government. And that could be recordings, data, audio, video, sticky notes with handwriting on them. We're talking about anything that we have a right to see by law. And we know that the fact that we can get this information reduces corruption. There's research that shows that. And in the handouts toward the beginning, I have a whole list of excellent peer-reviewed studies that show the benefits of transparency. They're helpful if you want to argue for transparency. You may run across an agency that balks or an issue that you're writing about. Use these studies to back up the idea that this is important. And there's actually research that shows that having records online improves our drinking water quality. It pressures government to provide better services. Even cleaner restaurant food. There's a study that showed that having these restaurant inspections public makes restaurants give us better food. So peer-reviewed research. In fact, for every dollar spent on public records related journalism, society benefits $287. That's a huge return on investment, and it matters. We're talking saved lives, more efficient government, even lower taxes because of these laws and this right to get information. And of course, let's all remember why this matters. During James Madison's birthday week, Sunshine Week in mid-March, it's to hold our government accountable. It's we as people are informed and we can better self-govern. So that's really the fundamental purpose here, the philosophy that makes this so important. Because as we see in other parts of the world, despotism can run amok, right? And we're unfortunately seeing that in Eastern Europe right now. And ultimately, this is power, right? Information is power. People who have it want to hold on to it, keep it, hoard it. People who don't have it want it. And it's this struggle back and forth over information. And so if we are adept at getting information, it gives us power. And we need to spread this knowledge throughout every part of the country, every part of the world, really. We need to empower people with these skills. So how do we do that? Well, step 2, it's knowing the law. I think that's critical for people to really understand their rights to this information, and going in to get information from an agency is good to understand that. So pop quiz, I am a professor, so I'm required to do this. Anybody have a wild guess? Put in the chat, what country was the first nation to embrace government transparency, to declare an edict that people shall have the right to information? Go ahead and write in the chat, anybody? Megan says the United Kingdom. That's a really good guess. but not quite. They passed a FOIA law, about 20 years ago, give or take. So who else? Who else? The U.S., Virginia, from Florida. Yes, you would think the U.S. of friggin' A. We're like a beacon of democracy, right? But alas, no, it wasn't us. Anyone else want to throw a guess out there? Good guesses. They make sense. They're logical. Well, I'll give you the answer. China. What? This makes no sense. What are you talking about? Well, there are some researchers who point to China as having a fairly progressive emperor some years ago, centuries ago, who believed that people should have information about their government. And if you weren't getting what you want out of the government, you could go to the palace steps with a drum and beat it until someone gave you the information. I kind of wish we had that system today, but we don't. So anyway, some people point to China. And the moral of that story is, if China could be progressive at some point and then turn into a country that's less transparent, what could happen to the US? And we've only been around a couple hundred years. So these rights can be fleeting. Society can change. And it's up to us to hold on to our rights if we really want them. Now, a lot of scholars debate that, and they say, really, the first country that passed a statute, per se, was Sweden and Finland in 1766. They were one country at the time. And they passed a law that empowered the press and said people have a right to government information. Now, to be honest, if you take a look at it, it doesn't look like anything we have today in public record laws. In fact, it's mostly a list of the fines and death penalty for writing things that the church and government don't like. Even though they said you have a right to do it, here's the penalty for doing it in ways that we don't appreciate. So I don't know, that too is tenuous. But Anders Chydenius, who led it, is a hero in Sweden. He even has a comic book about it, which is kind of funny. All right, so we finally get around to North America, and in the Declaration of Independence, you'll actually see a line where the folks are mad at England for putting records in places that are hard to get to. That's actually in the Declaration of Independence. They were frustrated. Information was not readily available. And among other beefs and gripes, right, that led to the Revolutionary War. And eventually, it took a while, we got around to passing a federal freedom of information law in 1966. By the way, it wasn't the first. Columbia had a law before us in the 1800s. Massachusetts had a law in the 1800s. Some states did. So it wasn't the first law. In fact, Louisiana had a law early on that was probably one of the most sophisticated ones way before FOIA was passed. So, but this came about. And the idea was we have a right to get information. And most of these statutes, they're pretty straightforward. They talk about it applying to government agencies. In most cases, it's executive agencies. In most states, though, their legislatures are subject to these laws. And in some states, the judiciary, at least in their administrative files. Yeah. So it's recorded information, as I mentioned. Just about anyone can ask. There are some states you have to be a state resident to use the law, which is a little weird, but whatever. And there are reasons for secrecy, so they call those exemptions. And if the government can show, then exemption applies and it could withhold some information. Fees, and really the only recourse for not getting records is suing. Now you'd think we have a great law in the US, and there's actually some folks who rate the strength of laws. And you could go to the RTI rating website and you'll see where the US ranks. You would think, okay, we're the best, right? No, we're actually 72nd in the world. We're ranked fairly low. Our law is not that strong. It's in the bottom of the half, not very good. And you see countries that have stronger laws than us, like Mongolia there, and Rwanda. You think that's kind of weird. In fact, the best law in the world is Afghanistan's FOIA law, strongest law in the world, followed by Mexico. Now, let's be honest, I doubt if you go and ask the Taliban right now for their emails and their budget that they probably won't give it to you. So, just because you have a strong law doesn't necessarily mean transparency works. But Mexico actually does work fairly well from what I hear. So that's something to keep in mind. If you want to learn more about federal FOIA, the nuances in getting records from federal agencies, I highly recommend the FOIA Wiki. It was created by the Reporters Committee for Freedom of the Press, written in English for average people, and it really gets into the nuances of the law. It's a great resource, and it's free. Also, of course, every state has its own public records law. And most of the records that most people go after are at the state or local level. And that's why we need to focus on the state public record laws really heavily. Federal FOIA, frankly, most journalists don't deal with unless they cover federal agencies, but most don't. So getting to know our state law is really important. The Reporters Committee also has a great guide to each state public records law. Each state's written by kind of the media law expert in each state. And I highly recommend that as a resource to turn to, as well as Muckrock. Muckrock has great resources on its website. This nonprofit out of Boston, out of Massachusetts, has a wealth of information I'll mention later as well. Our state coalitions for open government, about 40 of them in the country, 40 states and DC, they have a lot of resources on their website. So make sure to look for your state coalition for open government, find resources. A lot of state attorneys general offices have resources, which are really helpful, often written for government agencies, but we can use as well. And a lot of states have citizen activists and others who care about this and create resources on understanding the law. So get to know the law. That's great. Step 3, finding the records. This is critical. We have to be able to ask for specific records that agencies have. At least that's helpful. If we just write for, I would like all records pertaining to the transit system in town, that's a little broad and it may take a while to get. And in some states, they can turn that down because it is overly broad. So understanding what's out there so that we can help get them is helpful. Now, of course, a lot of people just turn to the Googles, right? That's helpful to find what agencies maybe to search for, but it's going to be a big fishing expedition. I don't recommend it. Another technique is to just go down to the agency or check out their website, talk to them, find out what they do, how they record information about what you're interested in. That's really important. Dovetails with the public records process is just good old talking to people, and that's helpful. A lot of agencies put on their websites their FOIA logs, what other people have already requested. Most federal agencies put this online. State and local agencies are less likely to proactively put this online, but you can ask for it, you can request it, and that can give you a lot of ideas of what others have requested previously. These FOIA logs can be really interesting. Here's a FOIA log from the Secret Service, and you can see a lot of interesting records that others have asked for. They give you lots of ideas. Another tip is to look at retention records, retention lists. This is where an agency is listing how long it keeps certain kinds of records and when it destroys them. This can be a wealth of ideas for what records an agency has. My university, University of Arizona, its retention list is about 20 pages long, or 10 pages long, single space. So that can be really helpful to get a sense of what's out there. Some folks have put databases, government records online searchable. Google Dataset Search has a searchable area. There's some others that could be helpful for finding information. And then some folks have actually put information online themselves that they've gathered, like at thegovernmentaddict.org. So a ton of resources. Again, in the handouts, you can find these websites and more. Muckrock, for example. In the 11 years they've been around, they've helped more than now 100,000 public records requests. And those records that are acquired are put online and they're keyword searchable. And you can see the letters, you can see the correspondence with the agencies, and you can see the files produced. Lots of amazing ideas for records that you can find. So once you know what you want, the next thing is to place your order. So, I use this word order. Now, normally you wouldn't hear that, right? You hear public records request, but I don't like that terminology. I think it's bad way to frame this, because when I hear the word request, this is what comes to mind. That's what I think of when I hear the word request. May I have some more records, sir? Yeah, and that's not how it should be. There are records we paid for with our taxes to be created, and the agencies are just holding on to them. They're watching them, they're caring for them, and when we want to go see them, we can put in an order. So to me, that's order. Now, I don't mean like order, I order you to give me those. We don't want to be arrogant, belligerent, but putting in an order for like a Big Mac, right? I want to put in an order for a library book, maybe order up some books on Amazon. I'm just putting in an order for the records that you all have on my behalf that I'd like to see. So that situates it where it ought to be, where we're in charge. We're not requesting from the government. We're just ordering up the information. All right. So that gets back to the kind of a document state of mind. So, all right, we're ready to put in our order for some information. We could just go ask, right? We could just ask the government, hey, I'd like to see a copy of this. Can you please get that out for me? And maybe you'll get it. And yay, we're all happy. You can go home and get what you want. But sometimes it won't end up that way. Sometimes they'll say, oh, well, you got to fill out our form. And that's okay. Feel free to fill it out. If it makes it easier and the system go faster, go ahead and fill out their form. In most states, you can submit a records request in any format you want. You could write it on a piece of paper in an email. You can, heck, I've heard some people write it on toilet paper, which is a little disrespectful. But the point is the law usually does not dictate the format of your order. So maybe you'll have to fill it out. And I would keep track of these orders. I used to just have a notebook. I'd write a page for each order. I'd keep track of who I talked to, the date, all that sort of thing. You could use Excel. There's other techniques like iFOIA. It's an online free tool by the Reporters Committee, really useful for federal FOIA in particular, tracking requests and orders. You may have to be asked to create your own letter, and there's some good tools for that. The Student Press Law Center, for example, has a request letter generator that's been used for since 1997, and it's very handy, and it creates a great letter that's really easy to create. It adds the legal mumbo jumbo. You don't have to remember the statutory citation for the law, and it's really simple and straightforward. So you could do that. I would take a look at letters submitted to the same agency through Muckrock by others. You might take a look at it, see how the letters were phrased previously when they were successful. In fact, Muckrock has a cloning technique to their site where you can clone successful letters to certain agencies for certain records that might increase your success. As some people know, there's certain requesters that have certain rights. They could get expedited review and free copies. Journalists count in that. Researchers, even college students now get expedited review and that sort of thing. So if you get that, ask for it. And heck, even if you don't qualify, it doesn't hurt to ask. Why not? At the state level, that typically is not in the law, but it doesn't hurt to ask, especially if it's for a public purpose. I recommend, and Grace is going to talk later, a lot more specifics of really good letters and appeals and this sort of terminology. By all means, include your contact information. I think most folks are recommending nowadays to be specific, maybe even include keywords. We're seeing the courts frown on requests that say something effective. I want records, all records pertaining to or related to this topic. They're just saying, hey, that's way too broad. Let's be a little more specific here. So being specific, they call that perfecting your letter, making it zeroing in on what you really want. I think that's helpful. Very good to cite the law in your letter. There have been at least 3 or 4 experiments now that show that when you do so, it increases your success, chance of compliance by the agency. By all means, ask for an itemized estimate of any costs that might be charged to you. Hopefully, there'll be 0. And I always recommend trying to get the electronic versions of the records, since records are all electronic now. I have not seen a typewriter in a government's office for a long time, and they don't handwrite much. So feel free to ask for it electronically. That ought to save on copy costs. All right, so you put in your order and you want to see what they have to say. And so I'm going to talk about techniques, Jedi mind tricks as well, on how to overcome illegal, unreasonable denials that you may encounter. And we know we're going to encounter those. So on average nationally, here's based on FOIA audits conducted, you could see the success rates varies widely by the types of records requested. So yeah, maybe if you ask for city council minutes, 93% of the time you'll get them. Heck, I wonder why there'd be 7% that would deny that, but whatever. And all the way down to police crime logs. On average, police departments will illegally deny a requester this information that they're entitled to 3/4 of the time. A little irony there, right? Police should not be breaking the law, but they often do. So the most common response you're going to get is nothing. And what we're seeing in the data is more and more requesters are just being ignored. You submit an order and you hear nothing, no response whatsoever, which in most states means a denial, means you've been rejected. But it's a problem. I mean, at minimum, they're supposed to respond. So that's an issue. We're also getting a lot of runaround. We're seeing that. And so how do you do this? They'll point you to another agency. They'll come up with all sorts of reasons. They're too busy. Well, of course, be nice through this whole process. I think nicety is always a good way to go. And think of this as a maze. Now, I used to get angry when I was denied information. I'd want to pound down that door and get those records like a battering ram, right? I'd get angry. And I've learned that it's more of a maze. You run into a roadblock, a wall, you turn around, you find a way around it. You curve around, you go over it, you go under it, and you use different techniques till you get what you want. That's more productive. So think of it as a maze. And the first way, alternative route, is through an administrative appeal. So if you're denied information, make sure to submit a letter saying, hey, I'd like to appeal this, because I hope you reconsider. I really think this is public. less than 1% of FOIA requests, denials are appealed, according to data. And yet, there's several studies that show that if you do this, about a third of the time, it'll cut some records loose. So it's free, it can't hurt. Typically, it'll go to the agency's attorneys, and they'll look at it and go, oh yeah, this is public, go ahead and give it. So it doesn't hurt, give it a shot. You can also seek out some mediators to help. So at the federal level, the Office of Government Information Services can act as a mediator to help work through this, answer questions, that sort of thing. They don't have authority to give binding decisions, but they perhaps could help. And it's a small staff. They literally only have 10 people to handle 4,100 complaints a year out of the nearly 900,000 FOIA requests submitted at the federal level. So they're stretched thin and they don't have a lot of authority, but it is an option. About half the states have some mediation type entity, often with the Attorney General office. Sometimes it's another office on its own. There are a few states that actually have independent commissions that can issue binding decisions without going to court. So if you live in Pennsylvania, New Jersey, Connecticut, or Ohio, you're in luck. You have independent avenues to get satisfaction without hiring an attorney and suing. Everybody else, sorry, you're on your own. And we'll talk about litigation later in this session. Well, not everybody has the time to sue. And as Megan puts in the chat, I've had requests from federal government take years to even get anything. So how do we get the information quicker? Well, we got to use our noggins. We got to use psychology, persuasion sometimes. It doesn't always work, but if we learn how to persuade people to get information we need, we might be able to avoid litigation and just working with people. And so let's talk about that. Let's talk about the psychology of access. And in your handouts, you'll see a section on this, such as principled negotiation. So we can apply the same tactics, the same strategies used in the business world for negotiating, for the art of the deal, dare I say. I should not even said that. For negotiating what we want. Pardon me. And so we're looking at what is in their interest in the agency. Why are they saying no? What is behind that? Maybe I can dislodge that concern and get the information coming my way, getting to yes. Also, there are hard tactics that we can use, and there's research that shows these are effective. Peer pressure, for example, could be very effective in this realm. If I'm not getting information from, say, Phoenix, city of Phoenix, I go get it from Tucson. Then I go back to Phoenix and I say, hey, I don't get it. Tucson gave me this information. Tucson's better than Phoenix, especially if they're neighboring cities or neighboring counties. They're more likely to give you the information. They feel peer pressure. They don't want to be an outlier. So that can be an effective way to cut records loose. Authority is effective. What we found in the research, that citing the law, having a letter written from an attorney, doing what I call a watchdog pile, getting a bunch of journalists together to go after the same records for a joint project, perhaps, that they localize to their own counties or cities within a state. This authority can have huge influence in getting records. Now, you may be charged a lot of money for copy fees, and I encourage you to challenge these. Interestingly, very few requests actually come with copy fees. In fact, only about, I think, 3% public records requests are charged fees. And they're often used to force requesters to narrow their requests particularly at the federal level. A lot of agencies will charge, say, okay, you can have all these records, but it'll take 7 years, 20,000 hours of staff time, and cost you $2 million. And so what they're doing is they're basically forcing you to narrow the request. They're saying it's too broad. We can do this for you, but it's unrealistic. Working with the agency, you can narrow, and you can often get the information for free or very little bit. So that's something to really look at. And in your handouts, there's a whole page, I think 10 tips on how to eliminate or greatly reduce copy fees. I had been requesting government data as a journalist since the 1980s. And in my entire career, I never once paid for a database from the government. I always figured out how to get it for free. And it's just talking to them, because data, it's not that hard generally to export and copy. It doesn't cost any paper or toner. So it's just a matter of staff time. And there's lots of ways to do that. Now, ultimately, if you're turned down, you use all the psychological tactics that are in the handouts, and you're still denied illegally, really your only recourse is court. And Grace is going to really help us understand the nuances of that. I want to say a lot of people think there's no way I can do that, but you can. There's this fellow, Jorge Rojas. He was a sophomore student at Arizona State University. He submitted some FOIA requests for data from the FAA, and they turned him down, and he got mad. So he Googled FOIA lawsuit FAA, and up came these other lawsuits others had filed. He just copied and pasted that into a complaint, updated it, and then went down to the federal courthouse, paid the filing fee, filed suit. A couple weeks later, he won on summary judgment. The judge said, "Oh yeah, this is public, give it to him and pay his filing fee." He filed hundreds of FOIA requests of the FAA, and he ended up suing them 4 times and winning, all on his own. So that goes to show, if you're tenacious, anybody could do this. So there we go. If you get the records, you win, tout it. Tell everybody, make sure all the agencies in your state know, don't mess with you, don't mess with the public, don't mess with this law. So that's kind of what it's all about. And then finally, the last step is just do it. This is something that it's like a muscle. And the more you exercise it, the stronger it gets. If you let it atrophy, it gets pretty weak. And what I find is with my students, when I force them to go out there and submit dozens of records requests in a semester, at first they're so scared and they don't, oh no, I have to approach government, it's intimidating. But by the end of the semester, they feel confident and they like, I can do this. And this isn't so bad. And so just doing it and practicing can really help. In fact, that was the thing that probably helped me most as a journalist. I got to where I set aside 1 hour a week, just 1 hour. For me, it was Friday morning, a slow part of the week. And I would come in and turn off the email and all that. And 1 hour a week, I submitted a public records order every week, 1 a week, and followed up on my existing orders. Well, if you do that, that's 52 public records orders in a year. And if you get awesome records just half the time, that's still 26 amazing records that'll help you. And if you're a journalist, help the public. It also helped me get really good at it. And it kind of trained the agencies to get used to it. I didn't do willy-nilly stuff to waste their time, but you do it to where it's useful, and then they get used to it. And part of it is just getting agencies used to it, because especially small towns or small agencies, they're not used to handling a lot of these or often, and it may be a surprise to them, and they may balk at first, but if you get them used to it, it can really help. All right, let's see. I will be happy to answer questions at the end here, it looks, because I think we're going to go to Grace, who's going to tell us some amazing things, because while I come from the requester side of the world, Grace has seen how the sausage is made in the background. And she's also very smart, much smarter than me. She is like a law degree. And so she's going to impart some knowledge that I think will be really helpful. All right, Grace, I will stop sharing and let you take it away.
Okay, thanks, Dave. That there was a lot of information in Dave's presentation, and it really sets the stage for what I'm going to talk about. And you'll see I recommend a lot of the same resources. So let me share my screen. Okay. There we go. All right, let's see if this is going to work. Okay, so we're going to talk about FOIA and public records litigation. And sort of before we get started, I do want to set the stage a little bit. So the Freedom of Information Act, as Dave referenced, there's the federal act that applies to all federal agencies, but at the state level, there's 50 different laws. They all differ a little bit. Hold on a minute, let me see. Is my slideshow going to work? Okay, here we go. Okay, so federal FOIA litigation, under the federal FOIA, you have the right to sue the federal government if they don't provide you records, if they provide you records that with a bunch of redactions that you don't agree with, if you think they didn't look hard enough for the records that you asked for, you are by statute allowed to sue as soon as the 21st day after you file your FOIA request. Now, for those of you who have ever filed a federal FOIA request, and for those of you who've ever done any business with the federal government, guess how much stuff gets done in 20 days by the federal government? Not a lot, right? So most of the time you will not have any kind of response in hand by the time the statutory time period expires. So typically FOIA requesters do wait a little bit longer before they file suit, because often it's not that productive to sue on the 21st day. A lot of times FOIA offices in federal agencies sort of don't have a good idea of what's going on by the 21st day. Maybe they haven't even, looked at your request yet. So the statute of limitations on FOIA claims is 6 years. So, and that's after your cause of action kind of accrues. So if the agency takes 10 years to respond to your request, it doesn't mean that you can't sue them after you get the response. You certainly can. So it'll be 6 years after you get a response from them. So common causes of action are constructive denial. That's where you filed a request and the agency hasn't responded to you. Search challenges, where you think that the agency has not done a sufficient job of looking for the records. Exemption challenges, which is where they've perhaps taken too many redactions or redacted things under an exemption that you don't agree with. And there's also requester and fee categories that are at issue. I think Dave mentioned that there are quite a few categories of requesters that would be entitled to a fee waiver or expedited processing. And if you ask for the special treatment and you get turned down, that could also be the subject of a lawsuit. So public records litigation. At the state level, you're going to have to look at the specific law of the state that you've filed your request in. Every state has their own public records or freedom of information law. Some states call their laws public records laws. Sometimes they call them FOI laws. Sometimes they call them Sunshine Act. So even the names of the laws can differ. Most states give requesters the right to sue agencies under their public records law. Some states, as Dave did refer to, have commissions that can provide some kind of quasi-judicial relief. So Connecticut and Pennsylvania are two states that have FOIA commissions that can issue orders directing agencies to produce records. It is not required for you to go to these commissions, but if you do, you sort of have that intermediate level before you have to file an actual lawsuit in state court. Other states such as Florida offer voluntary mediation programs. Some states have certain orders that can be judicially enforced by the state attorney general. Massachusetts is one of these states. So once you obtain this kind of quasi-judicial relief from a state agency, the state attorney general can enforce that order. In the case of Massachusetts, it's called, you would file an appeal to the supervisor of public records in the office of the Secretary of the Commonwealth, and then the supervisor of public records issues an order to the agency directing them to, say, conduct a search or produce certain records to you. The agency doesn't act on that, the attorney general can enforce that. That is not the same as filing a lawsuit in state court against the particular agency that you've requested records from. So the cause of action can vary from state to state. Most states have a cause of action, a statutory cause of action under their public records law. However, in some states like Ohio and Texas are two examples, you'd have to bring what's a lawsuit called where you're requesting a writ of mandamus. And that's just kind of a fancy, Latin way of saying you're bringing an action to force the agency to do, to force a governmental body to do something that's required under the law. But it is a particular procedural issue that you kind of have to deal with. So it does get a little bit complicated. It's not always totally straightforward. And I'll get to that a little bit later in the presentation. Also, the remedies under state law might vary. Sometimes the court may order the agency to give you the records. Sometimes they may require the agency to let you inspect records. There's different remedies under the law. And also fee shifting provisions under state laws can vary, meaning under the federal FOIA, if you sue, as Dave talked about the example with the Arizona State student where the court ordered the agency to pay the costs to the student that were associated with his suit. Under federal FOIA, there's a cost shifting provision where if you win your suit, you can recover attorney's fees and costs. That's not necessarily true under state law. So that's something that you kind of need to be prepared for. Look at the individual state law to see if you will be allowed to recover your state costs, the cost of litigation. As Dave also referenced, the Reporters Committee for Freedom of the Press Open Government Guide is a terrific resource. It's extremely detailed. It is written by lawyers, so some of it's kind of dense, but it is an excellent resource that gives you a ton of information about not just the Open Records Act, but also the open meetings laws of each state. And I highly recommend that. Okay, so you're thinking about litigation. What are some things to consider before you file suit? How long has it been since you filed your request? How many records were you expecting the agency to find? Did they provide you with a response, but it was just a lot less than you thought that there should be? You know, sometimes people ask for records, say about, you know, local crime statistics in their area, or they're asking for police reports, and you know, you think there should be 50 police reports, and you know, you get a response that has only 3. Does something seem weird about the volume of records that that you've received back? Do you have resources to hire an attorney or get legal assistance from, you know, law school clinic or other legal services provider? While I definitely admire the Arizona State student for showing the initiative and the persistence to file his own lawsuit, it can be a complicated and time-consuming endeavor. So, but there are sources of legal help out there that you can access for little to no cost. So those sources of help are out there. While I was at the Department of Homeland Security, I litigated against many law school clinics, and they basically had a mini army of law students working on the cases, and they file a lot of pleadings. So that help is available though. So if it's something, if it's a situation where you do feel like litigation is the only way to get what you want, you know, look for those sources of assistance. And what are some ways to get records without litigation? So we're going to talk about all these things in some more detail. Okay, so first, what I want to sort of run through very quickly is an agency response primer. So this is from for an insider's view into what happens in an agency, federal or state or local, when you file a FOIA, or when you file a public records request. So at all levels of government, public records, FOIA, it's all under-resourced. So most places aren't going to have huge staffs that are just sitting around waiting for your public records request. So that's why there's a lot of delay. You know, when you file a public records request and, you know, you're sending it to the police department, the police department's like, hey, our #1 job is to, you know, fight crime. It's not to answer these public records requests. So sometimes agencies don't take public records requests very seriously. So how do agencies respond to FOI PR requests? So typically agencies receive requests by mail, email, through an internet portal, and some state laws even allow requesters to make their requests verbally. Some states even allow anonymous requests. And I sort of puzzled about this because I was like, how does this work? So you would contact, I think Florida is one of these states actually. You contact the agency, you make the request anonymously, and then you have to call back to get the results. I don't exactly know how they verify that it's you, but there is this mechanism to do it. So once a request is received, it has to be evaluated by staff members to see if it's quote unquote perfected. And what that means is they're looking at what you're asking for to see if they can figure out what those records are. So sometimes we ask for records and we say, oh, we know you've got to have, you know, such and such type of record, but maybe we used a different terminology for it. Maybe we use kind of layman's terminology, and the FOIA office is kind of sitting there going, well, can I figure out what this requester is actually asking for? And until they do, and they may come back to you and ask for more information, that in an ideal situation, that's what they do. They come back to you and they say, hey, we're not sure what you're asking for here. Could you give us a little bit more information? A lot of agencies aren't going to do that. They're just going to send you back a denial letter that says, you know, we don't have that because, you know, you called it a report and, you know, we call it an evaluation. You know, that's probably a big exaggeration, but that kind of thing, right? So until the agency staff can figure out what you're asking for, they're kind of going to hold your request in abeyance. So after they've determine that your request is good to go, it's, we can reasonably figure out what you're asking for, most agencies will send you some kind of communication that gives you like a tracking number or something, some way to identify your requests going forward. So once the agency figures out what you're asking for, they're going to send your request to the persons or offices that they think might have responsive records, and ask them to search for records. So imagine if you send a request to the federal U.S. Department of Justice. It's a huge agency, tens of thousands of employees. So they have to figure out which of these tens of thousands of employees and which offices might have responsive records. Or maybe you've sent a public records request to, the local water authority that has 4 employees. That's a lot easier for them to task it out, right? These 4 people, if the records exist, one or more of these 4 people has to have them. But it's basically that kind of process where we look at the request, figure out what you're asking for, figure out where it should go. So one important note to make as you're formulating your FOIA request is that not all operations are going to be centralized. So if you're looking for records from your local, utility, you send it to the mayor's office, it may not work. So you need to look carefully at, the websites of your local government to figure out whether, do they have a centralized location where if you send it to the mayor's office and you're asking for records about, the water company, will they redirect that FOIA request to the water company, or are they going to require you to file that FOIA request on a particular agency? Very true at the federal level, although at the federal level, most departmental level agencies have a headquarters office where if you send it to the headquarters office, they will route it to the appropriate place. But there are agencies that don't work like that. FBI is one of those places. If you don't identify the correct field office, FBI headquarters will not help you with that. So it does feel a little bit like hide the ball sometimes, but that is something sort of important to keep in mind. So once the request is tasked out for search, the people and offices that receive that request search for the records. Ideally they search for the records, they collect the potentially responsive records, and they send those records back to whoever's processing the FOIA. In federal agencies, there's a FOIA office and a FOIA officer and a staff that is trained to process FOIA requests. Not always true at the state and local level. Sometimes it's the county attorney's office that's processing a FOIA request, or sometimes it's a clerk. Sometimes, in very small places, it could be, administrative staff. In very small places, it could be you file FOIA requests on the mayor. It could be the mayor, herself that's processing that. So these are all sort of differences. The smaller an agency gets, the sort of closer people are going to be to that processing. But as Dave pointed out, they're also likely to be less familiar with how the process is supposed to go. So once the records are collected, reviewed, and processed, the response gets sent out. I've really sort of truncated this very much. Usually what happens is when the potentially responsive records come back to the processing folks, they review the records, look for information that needs to be withheld. At the federal level, there's 9 broad exemptions. They are almost all discretionary, but there are some that are mandatory, like privacy exemptions are definitely cannot be waived by the agency. Also, classified information, law enforcement information, although there's some leeway on law enforcement information. At the state and local level, there's a slew of information categories of information under almost any state scheme. They're not always put together neatly, like at the federal level in one statute. Sometimes they're all over the place. There could be, a line in, a statute about water towers that says, oh, information about water tower capacity is exempt from the State Sunshine Act, for instance. I think the Florida state exemptions, there were exemptions in something like 300 plus different state statutes. So it can be very hard to track down, like once you get a response and information has been withheld from you, it can be very hard sometimes to identify what the source of that authority is. But that is definitely a place where the Reporters Committee Open Government Guide can be very helpful. There's a pretty exhaustive list of categories of information that are listed for each state. And it sort of explains what the authority for withholding that information would be. So the way I've kind of explained it, sounds pretty straightforward, right? Sounds pretty much like an assembly line. FOIA request comes in, look for the records, process them, and out comes your response. However, it's actually more like, this crazy pile of spaghetti. And the reason is that none of this is totally straightforward. So FOIA or public records is an iterative process. And, one of the things, and the reason I say that is that agencies, whether they be federal or state and local, deal with literally tens of thousands of matters, topics, programs, all the time. The person or entity or office that receives your FOIA request, it's kind of their best guess about where they're sending it to, who might have the records. So they could send it out to a bunch of offices or a bunch of people, and those people come back and they say, no, actually, you sent it to me, but it really needed to go to, Brian down the hall, or it needed to really go to the Office of Public Affairs over there. So many times a FOIA search, instead of being a very linear process, is actually a series of, okay, sent it here. They came back and they said, well, we do have some records, but you should also send it to these 3 other offices. And then when I looked at those 3 other offices, they referred me to 4 other offices. Sometimes records come back to the FOIA processor and they look at the records and they say, oh gosh, I can tell from these records that there's, 46 other people that also need to look for records on this request. So at the end, it's gone back and forth and, all around, and it's kind of, it's just not as straightforward as we might assume. Oh, and sometimes once potentially responsive documents come back to an office, you could look at the records and say, oh gosh, these records also have equities that belong to a whole nother agency. So we need to talk to that agency before we process these records or before we make any release of these records. That just sort of adds time to the whole process. The other wrinkle would be, oh, well, sometimes you file a FOIA request on, a state or a local agency, and they actually have records that belong to the federal government. And the federal government, through some kind of agreement with the state agency, says, okay, if you get a FOIA request for these records, you cannot release them. And so those records have to be referred back to the federal agency. And you will have to file a separate FOIA request on the federal agency to get those records if that's how it comes down. So let's talk a little bit about agencies and technology. So agency records are typically a mix of hard copy, electronic, and database records. They're records that are very easily accessible. Like, maybe you've filed a FOIA request on the mayor of a small town and he's got a filing cabinet in his office, and he can just open that filing cabinet, find the records, make a photocopy, and there you go. Or you've asked for city council minutes, and those minutes are recorded electronically. They're all in one place, and that's an easy record to find. There's other records that are incredibly difficult to find. Sometimes they're very old, or you know, they're in a database, can't be easily extracted in the way you're asking for. You know, sometimes we just don't know where to look for them. So technology, agencies are often very behind on technology. And we are living in the era of big data. I looked this up, I Googled it, but so something like 2.5 quintillion bytes of data are generated every single day. Now, that obviously doesn't equate to like the government is generating that much data, but you can see just from that little, you know, that little factoid that government is also dealing with a huge big data issue, right? It's hundreds of thousands of people across the country emailing each other 50 times a day. You know, it's a huge problem to store information, to access information, and to produce information. So most agencies, be they small agencies, large agencies, state, local, federal, they don't have access to a lot of like top shelf, you know, software. They might be using something kind of as rudimentary as, you know, Outlook to search emails. So it's not the best tool for culling through massive amounts of data. And it can be, and it usually is due to, you know, financial issues. There's just not enough money for governmental agencies to buy the kind of technology that they really need to make this process faster and smoother. And, you know, certain types of data need to be walled off, right? Law enforcement data, you know, it's not something that they want everybody mucking around in. So there's some technological sort of firewalls that are in place, you know, in governmental agencies that prevent, you know, easy access to a lot of data. And yes, you know, agencies are probably using outdated and inadequate tools to cull through data. Okay, so let's say you get through this whole process and you're like, yeah, you know, I think I'm going to need to sue. One thing that Dave brought up, which is really important to remember, is take advantage of the administrative appeal process. It is at the federal level, it'll probably get you in front of an administrative appeal authority that it's usually counsel's office. You know, you'll get another set of eyes on the request, and you know, that can be a way for the agency to kind of say, hey, wait a minute, yeah, we did not do a good job, let's go back and do it again. Doesn't necessarily mean you're going to get the results that you want, but you have a better chance. And that process is free. It's pretty simple. Usually you can just file electronically, so that's something that you want to take advantage of. At the state and local level, it's going to be a little bit more hit and miss. So that's just something sort of to try to keep in mind, that it will give you an extra layer of review before, you know, you get into having to file a lawsuit. So when we talk about litigation, number one, know what you want. Did you draft your request with as much information as you could? Be specific. Really avoid what I call any and all syndrome. I know that it's very it's hard to assume good intent on the part of governmental agencies that are looking at your FOIA request. But if you go in there and say, I want anything related to referencing any and all, if we think about big data as a problem, you could be talking about tens of thousands of pages of records, hundreds of thousands of pages of records, most of which are not going to be useful to you. So think about being as specific as you can. Dates, names, places, titles, any identifying information you can put in your request is helpful. Look on agency websites, look for org charts. If you can name the title of the person who you think might have the records, or the name of a government official that might have your records, that's very helpful to people trying to process that request. At the federal level, there's also system of records notices that are published in the Code of Federal Regulations. Usually you can get information about each federal agency's systems databases on their website. And if you look at the system of records notices, it tells you what information is being collected in those databases. And it also lists the reasons why it could be released without need for a Privacy Act waiver if it's personal information. But it does give you a lot of information about what types of records are in that database. And it can be very helpful if you can name a specific database that you're looking for records. Also, provide links to media reports or agency press releases if that's where the initial information for your FOIA request came from. All of those are, important, like sort of breadcrumbs, I'll call them, to help agencies to identify exactly what you're looking for. Make suggestions. If you are in litigation, and I'll just say like a typical litigation case usually is, I filed a FOIA request, it's been 6 months, haven't gotten anything, I don't know what's going on, I'm frustrated, I'm gonna sue the government. And the government comes back and says, oh my gosh, well, we looked for records and I think we have 200,000 pages of records. It's going to take 5 years to process them. And you sort of say, well, what's going on here? And one thing that you can do as a requester is to say, and Dave also talked about this a little bit, suggesting search terms is a great way to open conversation about the search for records. But be a responsive listener and hear what the agency says about why certain search terms won't work with their capabilities. I'm going to give you like a little bit of a war story. One of the cases that I worked on, a nonprofit sued the Department of Homeland Security asking for information about a detention bed mandate, immigration detention beds. We said, okay, we conducted a search. We used the word bed in the search because, even as sort of longtime agency employees, we thought, well, what other context could the word bed appear in, in a federal agency? It doesn't make any sense, right? As it turns out, the search returned almost 1 million records. And we're like, there couldn't possibly be this many records about detention beds. However, what we didn't account for was apparently, I think most of you well remember the Deepwater Horizon oil spill in the Gulf of Mexico. Apparently, the term seabed was used extensively in that investigation, in that litigation, and literally hundreds of thousands of pages of records from Deepwater Horizon got mixed in with this detention bed case. And we didn't know until we started going through the records. Afterwards, we sort of did this Monday morning quarterback, and I said, well, that doesn't make any sense. I would have never thought that they would use the term seabed. I would have thought they would use the term seafloor. But apparently seabed is a, marine term of art. And that was something that was like unforeseen to the people who were conducting the search. Agency systems, particularly email, can contain records on thousands of subjects. And so even though we kind of might get some tunnel vision about, what we're looking for and how we use certain terms, and we might think that's the only possible way it could be used in this agency context, that could be really far from the truth. So if we use terms that are too common, it can generate millions of search results, which really just doesn't help us move the ball forward, right? While we want to suggest terms, we also want to hear the feedback from the agency about why that term, may or may not work. Maybe they can suggest something in lieu of that, something that we can compromise on. Okay. Oops. Uh-oh. Sorry, I skipped ahead. Sorry, I'm trying to back this up. Nope. Okay, here we go. All right. So the second on the list of litigation, or the third on the list of litigation strategies, is to be flexible. There could be more than one way to get what you want. Another example from a case that I worked on, a requester had filed suit on a request asking about a particular cybersecurity program. The search generated something like 300,000 pages of records. And at least 50,000 pages were article compilations. And some of the compilations were hundreds of pages long, but there was at least one mention of the cybersecurity program, out of those hundreds of pages. So what we suggested was that we would search each record and we would produce the page that program name appeared on. And the requester would take a look at the page, and if they wanted more information, if they wanted the rest of the document that that was part of that record, we would process it. But as it turns out, I think we ultimately produced something like less than 500 pages of records, and they weren't interested in seeing any of the rest of it. So that's kind of an extreme example of where that worked out really well, but it is a sort of different way of looking at this record set. So instead of the agency having to look at every page of those, 50,000 pages, they said, okay, well, here's the one page of this record where this particular term shows up. You take a look. Do you want to see the rest of that record? And they weren't interested. So the fourth suggestion is to think outside the box. Are there creative ways to get closer to the records that you're looking for? Are you willing to eliminate categories of records you aren't interested in, even if they contain the search terms? Can you eliminate news clips? Can you eliminate article compilations or other documents that are already publicly available? All of this cuts back on the amount of time it takes the agency to look through all of these records. If they pull something up and it's, a bunch of news clips, they can just, put that in the, dump pile. Can you eliminate records that have personally identifiable information? That's not always going to be possible, but sometimes you just want anonymized records. Can you work out a compromise where anonymous data is produced in lieu of the actual records? So sometimes that works if there's an agency that keeps a lot of forms, for instance. They can possibly do a database pull in lieu of producing those individual records that then are going to have to be redacted. So can you agree to eliminate the non-responsive portions of otherwise responsive records? This can be very helpful if, good examples, if there's an email chain, you're talking about, the subject of the FOIA request for 6 emails, and then the next 7 emails, the employees switch and they're talking about something else. If you can just eliminate those other 7 emails, that cuts the processing time in half. And number 7, ask the agency if they're willing to prioritize the records you want the most. So if you have a multi-part FOIA request, could they possibly say okay, the most important parts of this FOIA request are parts 4 and 5. Could you prioritize those records? This isn't always going to be possible. A lot of times, particularly if records have been culled with search terms, everything's just in a lump. So they're not going to know whether it's responsive to part 1 or part 7 or part 3 or part 6. So that's something that you could possibly work out in a negotiation with an agency. So these are all strategies that can be useful even before you file your lawsuit. So just keep that in mind. You know, try to open a dialogue with the FOIA staff, and try to presume goodwill as much as you can. Most of the time, they're just trying to help you, but they're struggling with too many requests and not enough time. Contact the staff early and often, and contact the Ombuds office for help. All federal agencies have an Ombuds person. That's even before you get to the NARA, to the Office of Government Information Services, and many state level agencies do as well. It's probably not going to work that well, at the county level and more locally, because they don't generally have sort of fleshed out public records staff. But get to know that staff, call, develop friendly relationships. Those are all ways that can sort of help you get to yes. Okay. So questions? Stop sharing my screen.
I have a question. Can you hear me?
Yes.
Okay. I filed a report for a presidential library, and they sent us the documents. And they were all redacted, like almost the whole thing. And then I filled out the MDR to have them sent somewhere to be unclassified, and it's been like 2 or 3 years.
That's not surprising.
Is that okay? I mean, if they've been
surprising.
in contact with me, like I'll ask them, if you've heard anything, if there's any of them that can be released, because you were talking about the 6-year thing, so I wasn't sure how all that worked.
Your cause of action has not even accrued yet.
Okay.
Basically, so, well, you could sue now. If you wanted to. I don't think that would necessarily like speed up the process a lot more. The cause of action really accrues when you get a response back from them that says like, oh, we did a review, we're not going to declassify this document. And it's classified documents are really hard because you don't really have enough information to know whether that's illegitimate or not. But sometimes it's possible, like let's say there's sort of mandatory declassification at like 25 years and 50 years, depending on the type of documents. So maybe you're like, hey, it's been 50 years, like I don't know what exactly is in this document, but it seems like something's not right here. And then at the very minimum, if you filed suit, they would have to provide more information, at least to the court, about what's in that document.
Yeah, because they charged us for them, and then they basically just give us blank pages.
Yeah.
Which I thought was kind of weird.
They're withholding, I mean, especially classified information. And actually, like, I'm glad you brought this up, because I'm actually giving another talk tonight at 7:30 through the LA Law Library, and I'll drop a link in the chat, where I talk about national security information. Actually, and this is in the context of UFOs and is the truth out there. So I will not be handling the UFO part. There are UFO experts on hand to do that. Michael Morrissey from Muck Rock will be speaking, as well as John Greenwald from the Black Vault, who has had very good results. He's been, pretty successful in seeking classified information from, various federal government agencies. So if anyone's interested, should be an interesting session. I'm going to just drop the link into the chat for registration.
Thank you for sharing that, Grace. And thank you, David, also for sharing information. I think 2 big takeaways: be specific and be nice. Words to live by, I think, for anyone in everyday life, but particularly when you're asking for information or when you're making an order for information, which I also appreciate reminding everyone that it's our job to ask for this information. It's publicly available. We should encourage, make sure that there's an open dialogue, and be readily available to ask for it. So we are coming up to a time boundary with our time. Are there any other questions for Grace or David? Michelle, I think you had a question you might have had earlier. I can scroll to it, or if you want to unmute yourself and ask it. I think it might have been.
I think it was mostly answered, but just in lieu of state enforcement, you know, what are other workarounds to push peer pressure for states, municipalities, et cetera, et cetera. But I think it was mostly answered. So if there's any other resources on that, but I think they've somewhat been exhausted from what I can see.
Great. I think the speaker on Monday, Lam, mentioned precedent. And I know, David, you also mentioned that of like, hey, this other agency gave me this information. So especially when you're looking for big data sets, trying to create some sort of precedent to go back and forth for. I know particularly with the communities that we work with trying to access information related to unsolved cases, we try and be as creative as possible because, as you can imagine, it's easy to say this case is still ongoing, even if it's a 40-year-old cold case. So how we can find info that may not be a police report or an autopsy report, but maybe it's related to search information or maybe another agency. So I love that idea of being very specific because reminder that these are all agencies with people working in them. So when you can offer something back, particularly if it's data that they have, if I can organize this for you or I can help you in some other way, getting back to that notion of being nice as well. So we have found that to be helpful, at least in our community, and we're always trying to find new and creative ways to kind of push there as well. All right, any other questions? Are agencies held accountable if records are actually lost? That's a great question, Dylan. David or Grace?
So I think some of you may have heard quite a bit recently about the at the federal level, the Presidential Records Act and the Federal Records Act, mostly in conjunction with some classified material that was removed from the federal government by a former President Trump, and then returned in somewhat of a haphazard manner. And records get lost all the time. There are penalties under both the Presidential Records Act and the Federal Records Act for sort of intentional destruction of records. But if things are lost, misplaced, it was not a willful destruction, it's just part of the cost of doing business with the government, for the government, I guess I should say. Even intentional destruction is not pursued very often. So, I would kind of say that the answer to that, unfortunately, is no.
And I see David dropped a great URL in here if you all want to hit that real quick. Awesome. Well, with that, I'm going to wrap it up and thank you both so much for sharing your expertise, your insights. Amazing presentation, amazing information. I'm sure everyone can agree. We've all learned something today that we're going to take with us and we're going to expand upon. So again, I appreciate both of you so much. Appreciate the partnership with the National Freedom of Information Coalition. And thank you everyone for participating today to learn more and to stretch your rights. All right. Thank you, everyone.